This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, B306. Did you know live Senate video is now available at youtube.com/@Senate of Virginia? Senate Committee Room, B306. This is the Senate of Virginia, Richmond, Virginia. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, B306. Did you know live Senate video is now available at youtube.com/@Senate of Virginia? Senate Committee Room, B306. This is the Senate of Virginia, Richmond, Virginia. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, B306. Did you know live Senate video is now available at youtube.com/@Senate of Virginia? Senate Committee Room, B306. This is the Senate of Virginia, Richmond, Virginia. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, B306.
All right, I'd like to welcome everyone to the 2025 meeting of the Virginia Commissioners to the Uniform Law Commission. And we have an agenda before us. Before we get started, I'll just say that we will take public comment in person at the end of the agenda. Unfortunately, we don't have a link for online public comment, but if you have a comment to make electronically, please feel free to email Emma Buck at the Division of Legislative Services, that's EBUCK, at dls.virginia.gov. All right. And with that, as we get started, I'd like to welcome everyone here. This is our annual meeting to prepare for the larger conference's annual meeting to consider certain proposed uniform acts, some of which will be on their final reading, some of which will be in draft form. Before we get started, though, I think it may be helpful if we could introduce ourselves, and I'll start to my left. Tom.
Tom Edmonds, life member of the commission.
E.M. Miller is one.
Right there.
Okay. E.M. Miller, I'm a life member, and before that, I was a state government employee for 38 years working for the General Assembly in 2 different capacities.
My name is Amigo Wade. I'm the current director of the Division of Legislative Services.
Thomas Galanis from Arlington, Virginia. I'm a law professor at George Mason University and a new commissioner.
My name is Emma Buck. I am staff for the commission and a legislative drafter for the Division of Legislative Services.
Okay, and I'm going to ask that Mary, if you could come off mute and introduce yourself, and then I'll go around to the other 2.
Hi, I'm Mary Devine. I'm a Virginia commissioner and a life member.
Great. And Lane, can you come off mute and introduce yourself?
Can you hear me?
Yes, sir.
Okay. I'm Lane Needler. I'm a life member, and I'm a retired law practitioner and academic.
Great. And Ellen? I think you're still on mute, Ellen.
There he is. Hi, I'm Ellen Dyke. I'm a Virginia commissioner and life member.
Great. And thank you, Ellen. My name is Chris Nolan, and I've been a member since 2023 or so. Also see that we have online Libby Snyder. Libby, would you introduce yourself, please?
Oh. Hey, everybody. I'm Libby Snyder. I'm a staff attorney at the ULC. Happy to be here, mostly just here to listen and answer any questions that come up. Thanks, everybody.
Thank you, Libby. And I believe that is all of the individuals that we have online. So with that, the welcome introductions and election of a chair. Historically, we've elected a chair for a term of 1 year. I'm happy to open the floor for nominations.
I nominate Chris Nolan for another term.
Second that if the second is needed.
Any other nominations, please?
I think that's by acclamation, I believe is the.
All right. Typically, we've done this by consensus, and we'll toss aside Robert's Rules of Order, given the small, intimate affair that this is. And thank you. I will do this for 1 more year, and then someone else can have the gavel. Emma, you want to walk us through item number 2, the readoption of a virtual meeting policy?
It kind of looks like a mouse got to the cord on that microphone, so I'm not going to use that anymore. So our virtual meeting policy, this is originally adopted June 27th of 2023. We did not have the appropriate quorum to adopt it last year, to re-adopt it last year. The code provides that this needs to be adopted annually. I'm happy to run through the content. This both relates to participation, electronic participation in meetings in which there is an in-person quorum. It also relates to being able to hold all virtual public meetings as authorized by code.
Okay. Any questions for Emma with regard to the policy? Emma, I believe that we need to take a vote. Is that correct?
Yes, Mr. Chairman, that's correct.
The people online just lost audio from Chris, FYI.
Thank you, Libby. Can you hear us now?
Yes, thank you.
Okay, very good. Emma, that vote, it's only those who are present, or is it everyone votes, but a majority of those present in person is required to pass it?
Everyone is allowed to vote because we have an in-person quorum.
Okay, so you've heard the policy described. Is there a motion to adopt the policy?
So move.
Is there a second? Okay. For this one, we're going to vote. Emma, do you want to just call the members? And if you're online, just come off mute to vote. And then Emma will record your vote and then return the mute if you don't mind. Thank you.
Commissioner Devine?
Aye.
Commissioner Dyke?
Aye.
Commissioner Edmonds?
Aye.
Commissioner Galanis?
Aye.
Commissioner Needler?
Aye.
Commissioner Miller? Commissioner Wade?
Aye.
Aye.
That's all affirmative.
Emma, with a unanimous vote, that policy is adopted, should we need it in the future. All right, this begins the portion of our meeting where we receive presentations by DLS staff on the acts that will be before the Uniform Law Commission later in July. So with that, we will start with the assignment for benefit of creditors. Yes, Lane.
Chris, can you hear me? This is Lane.
Yes.
I was going to, you probably can't read it from there, but I've got my Santa Fe hat on today.
Very good.
Informal welcome to Santa Fe before July.
Well, thank you.
Our 2 new commissioners, I spend about half my time there and half my time here in California because of grandkids.
Yeah, very good. Lane, we look forward to seeing you. Thank you.
Look forward to seeing you.
All right, Keelan? Yes. The floor is yours. Know that we may ask questions along the way, and which is typically our practice, that if something pops up that we want to discuss, then we'll ask you a question. And then after that, if you can continue on with your presentation. I would ask, though, for the benefit of the commissioners, tell us a little bit about yourself, where you went to school, and what areas that you work in at DLS.
Sure. Do I need to turn this mic on? Okay, perfect. My name's Keelan Cronin. I am a staff attorney at Division of Legislative Services. I currently staff House Appropriations. Before working with DLS, I was in Atlanta, Georgia. I had been to law school at the University of Georgia, and prior to that, I went to undergrad at Chapel Hill. So to get into what we have today, I'll be speaking with you about the Assignment for the Benefit of Creditors, the Draft ULC Act. This came into origin based off of a recommendation by the study committee back in 2023, and the drafting committee has met several times since then to create the draft that y'all will be reviewing in July. As hinted, this is an update. So what I'll be doing today is I'll briefly do a bit of a refresher on ABCs and also revisit Virginia law just to kind of remind you where we are. I don't want to spend too much time on that just because there haven't been any changes. And after that, we'll get into what the changes are actually to the Draft Act between the one that you'll have in front of you in July and what you saw last year. So to get right into it, the first baseline question we have is, what is an assignment for the benefit of creditors? It is essentially a business liquidation device that is used as an alternative to a formal bankruptcy procedure or a state law receivership. In an ABC, the assigner will voluntarily assign all of its assets to a trustee or a fiduciary, which will then liquidate those assets and distribute the proceeds to the assignor's creditors. This is generally seen as more flexible and more cost-effective than a bankruptcy procedure, just due to the fact that bankruptcies will have more regulations and more court filings. You know, there's more federal law involved. ABCs are a state law procedure, and usually they are much more flexible and much more quicker to wind up. As I mentioned just a minute ago, these are currently available on a state-by-state basis. There are several variations between states. Looking at those variations, one of the main differentiation areas you'll get here is common law versus statutory law. There's a pretty wide spectrum. There are some states that just have a simple statute that authorizes the use of ABCs, and then they will proceed on common law grounds, very hands-off approach. There are other states that have a highly detailed, highly regulated ABC scheme. It'll, provide for extreme, or not extreme, but more detailed, highly required notice requirements, powers of assignors and assignees, things of that nature. And they're just kind of spread all over the board at this point. The other thing to think about are ABCs and receiverships. Receiverships are a third vehicle or that can be used as a third vehicle for this liquidation winding up process. If you think of them on a spectrum, again, you're going to see bankruptcy law as the more regulated, more or less flexible, I should say, of the three. ABCs at the other end of that, and receiverships will be in the middle. They are typically under court supervision. They are typically also creditor-driven as opposed to assigner-driven, as an ABC is. There has been recently a bit of a trend to fold ABCs into receivership law. There are, I think, 7 states as of right now that treat ABCs and receiverships essentially identically. They just kind of include them both in the same statutory work in their code. What you see here is just kind of a visual representation of what I laid out. On the left-hand side, that's just kind of the decision-making process into coming to an assignment agreement, whether it's board approval, shareholder approval, depending on the corporate structure of the business using the ABC. It all ends up in that agreement between the parties, and then on the right-hand side, it will lead into the ABC process itself, which will begin with the sale of assets, any sort of claims processes where you are receiving claims from creditors to the assigner estate. And then you round that out with dealing with any sort of objections to those creditors' claims. And finally, once those have been resolved, you move into the distribution phase. And that kind of winds up the assignment once that has all been distributed to the creditors. Next, just quickly, looking at Virginia law, talking about that spectrum from earlier, we land closer to the common law side of that range. We do have ABC statutes in place, just a couple of articles in our Civil Remedies and Procedure title, handful of code sections. We split it into two. The first article is on the assignment of property. That is essentially where you're going to begin by filing that deed of assignment in the appropriate clerk of court, depending on where the property is located. And at that point, the trustee will give up to 10 days of notice to the appropriate creditors. They will then sell that property in either public or private auction and distribute the proceeds of that auction to the creditors. One other thing, or I guess a couple of other things that this article talks about, it mentions trustee substitution. So for an assignment of property in Virginia, it allows the majority of the unsecured creditors to agree upon a different trustee and then petition to the court for a substitution of trustees based upon that agreement. The ULC Act that, and we'll talk about this a little bit later, allows for the for-cause removal of an assignee at the request of the assignor, a creditor, or on the court's initiative if an action is pending. So that is one area where there is a bit of a difference between current Virginia law and the ULC Draft Act that y'all will be looking at later. Finally, in this article, there is also a process that allows you to kind of clean out the objections to the creditor claims. It lays out kind of the different scenarios in which that would occur and how that would be wound up. So it just has a process for that to make sure that it's clear. The other half of that is an assignment of wages, salary, or income. In this scenario, there is a petition for assignment by the debtor, and then that is followed by an appointment of a trustee by the judge. In the case of an assignment of wages and salary as opposed to an assignment of income, you will need the consent of the employer who is giving that wages or salary to the debtor before you can proceed with this sort of assignment. Following the appointment of the trustee will then disperse the income as it is received, first to the debtor as is usually arranged by the assignment agreement, and then after that to the creditors. Something to note is that any sort of wages, salary, or income that is assigned under this type of agreement is also exempt from garnishment, levy, or distress by other creditors, so this assignment will take precedent over other liens. And then the last thing that's kind of included in this article is similar to last, there are processes for termination of assignment under different scenarios, whether that be the assignment is simply wound up, there's nothing left, or the creditors have been paid off, or the assignment is not being carried out as the judge foresaw, and so there's just going to be a termination at that point just because it's not working the way it should have been. So we're going to get into the Draft Act now. What you see in front of you are the sections that are currently in the latest version of the ULC Draft Act. You can see here there are 29. Last year there were 25. That implies a bit more of a difference than there actually is. The number has gone up because there are a few sections from last year that were just broken out into multiple sections. The bolded ones that you see, 11, 12, 13, 18, 21, and 23, those are the areas that are going to be a bit more of a substantive difference from last year, and so that's what we're going to focus on today. But it is important to note that there will be stylistic and organizational changes throughout. So there might be some differences in language, but for the most part, outside of these particular sections, they are largely the same, like very similar. We're going to start with sections 11, 12, and 13. We're going to take them as a unit because they are originally one section from last year, the claims resolution section. I would like to point out that claims resolution in this case means just a creditor claims resolution through the distribution process rather than a disputed claim. So for section 11, now it just describes the allowed claims, the allowed creditor's claims. And in that case, an assignee must allow a creditor's claim if the creditor submits a proper proof of claim, which will be touched on in a second, and also the assignee does not dispute the claim before final distribution. Section 12 then gets into those disputed and disallowed claims and essentially just provides that an assignee may dispute a creditor's claim before final distribution by sending notice and a record stating the nature of the assignee's dispute to that creditor. Section 13 is that proof of claim mentioned in section 11. This language is actually essentially identical to last year's. It has just been pulled out and is now its own standalone section. It just provides the list of requirements that a creditor needs to fulfill in order to provide a proof of claim that will allow them to have that allowed claim that is described in section 11. Section 18, our next difference here is dealing with assignee removal and successor assignees. Again, a pretty simple change from last year. Last year, this section was only on assignee removal, and it was the same, which is that an assignor or creditor may request to remove the assignee for cause or if removal of the assignee best serves the interests of the creditors. What the section last year was silent on is that successor assignee. So this year, it also includes language that provides that in the case a assignee is removed either for cause or, if he, for whatever reason, cannot serve, that the successor assignee will be appointed, based on the assignment agreement itself, or if the assignment agreement does not say anything about a successor assignee, then it will be court appointed under the guidance of the judge. Kind of following on this court theme, the Section 18 last year from court involvement, this was a little bit squishy. Even last year, the draft act actually had two different alternatives contained in it as far as court involvement was put out. Alternative 1 last year was that a court may intervene in an assignment to the extent the court's jurisdiction was invoked by an interested person or as otherwise provided by law. Essentially, there wasn't really going to be any sort of judicial intervention unless it was pulled in or affirmatively asked for. The second alternative that they included last year was that upon the making of an assignment, the assignee would need to file notice of that assignment in the court of competent jurisdiction. And then after that, if a dispute arose during the assignment, the court in which that notice was filed would have jurisdiction to resolve that dispute. So this year, they have resolved between those two alternatives, and they have landed on the less judicially involved option. Essentially, what this section says is that a court of competent jurisdiction may hear and resolve a matter involving the administration of an assignment or the exercise of an assignee's powers and duties, and then following that may also issue an order related to those two issues. So there is no requirement that the notice of assignment needs to be filed with the court, and they're really only going to get involved in the case that they are affirmatively requested to do so. This is our final section. This is Section 23, Provisions Variable by Agreement. This is actually a brand new section. This was not included in the draft last year. It really just acts as guidelines for what may be changed in an assignment agreement as opposed to what is contained in the provisions of the Act. So Section 23 provides that the Act may not be varied by agreement except for these four sections. Sections 8A and 9A, which deal with the reasonable actions taken by the assignor and the assignee's fiduciary duty, those may not be disclaimed in the assignment agreement. What can be done to them, however, is the assignee and the assignor can, by agreement, choose the standards of action which will fulfill reasonable actions taken by the assignor and assignee's fiduciary duty. So they may not be disclaimed altogether, but they can be sort of altered depending on the agreement itself. Section 23 also says that the assignment agreement may alter the assignee's liability, which is described in Section 19 outside of the assignee's actions in bad faith or outside of bad faith, and also the assignee's duties to the assignment estate. The last thing that this kind of talks about is the within a reasonable time that you see there. There are a few things that take place throughout this draft act that describe an action that needs to take place within a reasonable time. What it says is that in the case of this happening, other than in Section 7A, which is the deadline for an assignee to send notice to a creditor of an assignment, that whenever the act requires an action to occur within a reasonable time, a set time may be agreed upon as long as that set time is not manifestly unreasonable. So that is kind of within a judge's purview, but outside of manifest unreasonableness, you can kind of set that reasonable time yourself. So that finishes up the main differences between these two draft acts. If you have any questions, I'd love to answer them. And if you think of any later, my email's there and I'm happy to help out.
Yeah.
A couple of questions. And I don't know how far you look behind the actual act itself, But if you read any of the report or background on the report, and were there any groups or whether it be members or observers that expressed any real doubt about provisions of this act?
So I watched a few of the informal draft meetings. There wasn't any sort of really substantial doubt or concern. Most of the things that were expressed were kind of questions on where language came from. Usually the drafters could point to either bankruptcy law, federal bankruptcy law, or some sort of language from the UCC where it came from. But there wasn't any sort of real hard pushback that I saw. I know I had reached out to the Bankers Association, the Creditors Association, a few different agencies and groups in Virginia, and there wasn't really any sort of hard feedback there either. So it doesn't seem to be an act that is really creating a lot of controversy, I guess I could say. But of course, I can't speak for everyone.
Mr. Chairman, I have several questions, if I could have the floor for a minute.
Please proceed.
Looking at the observers, what groups were represented in the observers that were following the commission? Could you tell by the meeting?
They didn't really say what their background was. It was really more focused on state by state.
Mm-hmm.
And of course, that was pretty wide. But there were the ABA representatives. There were a couple of practitioners who work in bankruptcy and liquidation law, people who just generally worked in areas that would have like an impact essentially based on this, but there wasn't necessarily a full readout of professional background necessarily.
Good. Mr. Chairman, one final question. You probably know more, well, you do know more about this act than certainly anybody sitting up here, I would think. If you were in a position where you could vote yea or nay, looking at what Virginia has and what this act provides, would it be a yea or a nay? You're among friends.
I mean, that's a tough question to answer. I don't think I really can answer it. I mean, what I can say is, there hasn't been a lot of pushback that I have seen. It really depends on how you want to look at, the pros and cons of either highly regulating or not necessarily highly regulating, but because Virginia has a lower statutory scheme in place for ABCs, putting this in, it just depends on whether you're more comfortable having more oversight and more guardrails in place for these kinds of procedures, or if you're comfortable with where it is now, which is essentially, common law governs and otherwise the agreement and contract law is in place.
I was on the drafting committee, so let me just say a couple of things in response to your questions. We had a bevy of observers from the Land Title Association, a lot of bankruptcy people, a number of judges who handle these kinds of matters, both in federal court in the case of bankruptcy and state court in the case of this remedy. And I would say that we had, by the time we finished, I think we had broad agreement that this was a good act and an improvement. There are many states that don't have much law at all, including Virginia. I mean, really hardly have any. And this provides a framework for resolving disputes and questions that does not now exist, and I think it would be extremely helpful for it to be adopted. I would say the main debate was over the extent of judicial supervision that was going to be involved. There are several states where an assignment is filed as a lawsuit, in effect, and a judge supervises it just like he does or she does a receivership. So that is an option, and there were practitioners from those states as observers and members of the committee, and nobody thought we should go that route. The emphasis was on creating an inexpensive remedy that does not involve a lot of court time and lawyer time and that sort of thing. So it's a pretty simple, straightforward act that should be largely self-executing. But of course, if a dispute arises that cannot be resolved between a creditor and the assignee, somebody's got to file a lawsuit and get it resolved. So that's why we provide that a court of competent jurisdiction can resolve these disputes if they occur. We just hope they won't in most cases. And I think most of these cases involve an estate that is not going to be sufficient to pay very much on the dollar. And so it's quite unlikely that this is going to involve a whole lot of disputes about a whole lot of really valuable property that, you know. So anyway, that's a little bit of the history. The chair of the committee is Ed Smith from Massachusetts, who is a very competent commercial law and real estate lawyer. And we had great people on the committee, great observers. And so this act is on final reading. I don't know whether it will survive final reading, but we hope that it will.
Tom, that was very helpful. If you would, if anybody has been on the drafting committee on an act that we have before us, it'd be helpful to give as much information as you just did, Tom.
Well, I'd have to do
No, it's helpful. It's very helpful.
And one final comment, if I could. I'd like to ask the attorneys from Legislative Services to take off your Legislative Services hat and be very, we're not legislators. We're just trying to get information to determine whether we are going to have any objections to any of these acts before they even presented to Virginia. So if you would, tell us what you really think whenever you hit a spot. Don't be afraid to say, this stinks or whatever. Right. Thank you, everybody.
Tom?
A few months ago, the drafting committee asked me to join them by Zoom because they were wrestling with the question of the assignee's fiduciary duties and whether those duties should be shaped by reference to trust fiduciary law. Where does the final version come out on that question?
That's not something that was really talked about too much in the most recent informal draft meeting, which is the one I sat in on. However, I'm happy to go back through and kind of review that and circle back later today.
Okay, or I'll take a look at the act myself. I just remember this was something that they were wrestling with, and that's why they asked me to join them to talk about trust fiduciary.
Mm-hmm.
All right, any other questions for Keelan? If not, thank you. Very well done.
Thank
Appreciate
you.
it. All right, Hannah? And as a reminder, introduce yourself, tell us where you went to school and what area is your focus in legislative services.
Yes. Hi, my name is Hannah. I went to the esteemed American University, Washington College of Law. Go Eagles. And for undergrad, I went to James Madison University. I've been with DLS for almost 3 years, and prior to working at DLS, I was at the legal aid in the Shenandoah Valley. And I focus on health law and social services law at DLS. All right, so this is an update from last year's act, the Judicial Interview Procedures of Children Act. It is now on its final reading. So this act provides a procedural framework for interviewing children. Do I do this myself? Oh, yeah. It provides a procedural framework for interviewing children in proceedings regarding child custody, visitation, parenting time, relocation, and other custodial rights. And it's not a source of authority for judicial officers to conduct an interview. It's more of a procedural framework to guide them in conducting the interviews. And because the Act sets standards for judicial officers, it might be more appropriate for a court ruling than for a legislative enactment. So the Act expressly excludes child welfare proceedings and juvenile delinquency proceedings from its scope because the constitutional and federal statutory protections for children in child welfare or delinquency proceedings differentiate these proceedings from family law proceedings. And this is the first update we have. So the 2024 draft did not exclude juvenile delinquency proceedings, only child welfare proceedings. So now it excludes both of those subject matters. And the Act applies only to a child interview, which is distinct from testimony by a child in a court proceeding. So a child interview is a less formal process conducted outside of open court in which a judge seeks to learn about a child's views. So I think typically it happens in the judge's chambers, just between the judge and the child and the child's attorney and guardian ad litem, if they have those. And the Act doesn't displace other laws of a state regarding whether an interview should be conducted. Again, it's just guidance. It's not supposed to replace or supersede any state laws that are existing. So a little bit of background about this draft. So state laws throughout the U.S. require courts to consider children's views when adjudicating child custody, parenting time visitation, and other family law disputes regarding custodial responsibility. So, for example, the Code of Virginia provides that in determining the best interest of a child for purposes of determining custody or visitation arrangements, the court shall consider the reasonable preferences of the child. So that's already in our code. And while the mandate to consider children's views is clear, the method for obtaining that child's perspective varies from state to state. Judicial interviews are widely used, but interview procedures vary significantly among states. Other processes for obtaining children's views include custody evaluations and expert testimony, appointment of a representative for the child, and in-court testimony by a child. And again, this act only covers those judicial interviews. It doesn't cover the other procedures. And judges often opt for judicial interviews, which is a less formal process of interviewing children in chambers, which protects the child from the courtroom and permits them to speak directly to the decision maker. Judicial interviews of children are not highly legislated in U.S. states. Some states have statutes or court rules that permit judicial interviews, but there is relatively little legislation that guides judicial officers as to when the process is appropriate, how to structure it, what procedural protections for the parties and the children should be provided, and what to do with the information shared by the child after the interview. So this is the first slide that describes the substantive updates to the draft. So we have a couple changes to the definitions. So the current draft now uses the term covered proceeding rather than family law proceeding to refer to civil proceedings relating to child custody, visitation, relocation, guardianship, private adoption, and the International Child Abduction Remedies Act. And something important to note here, so covered proceeding can cover certain aspects of a larger case. So for instance, in a domestic violence proceeding, if there's a child custody issue at stake, this act would provide guidance specifically for the child custody issue, but not the remainder of the domestic violence case. The draft now includes a definition of party to make it clear that the child is not considered a part of a party. And in addition, the definitions of judicial review, testimony, and views have been revised and tightened to clearly distinguish interviews from statements by the child under oath. So now diving into what the judicial interview procedures for Children Act will do. So the act provides factors for the judicial officer to consider in determining whether to conduct a child interview. And it's important to note that the judicial officer is always going to be the person presiding over the covered proceedings. So that will either be the judge or the magistrate judge. And these factors have been updated from the 2024 draft. So we'll get into that in the next slide. It also provides a process to meet the dual goals of protecting the child's interests and protecting the due process rights of the parties. And finally, it provides a procedural framework for the family law proceedings after an interview has been conducted. So these are the updated factors to consider in determining whether to conduct a child interview. So the 2024 draft included a presumption that an interview should be conducted arising from the child's wishes. And the feedback on this presumption was negative, since presumptions can implicate burdens of proof, mandatory findings, etc. So this presumption has been discarded, but the child's expressed desires to communicate with the judicial officer is included as one of the factors that the judicial officer must consider. And this feedback was discussed at great length in last year's drafting meeting. So this is just an update. They updated the draft based on that negative feedback that was given. And in other words, the court must consider a child's expressed desires, but the weight to be given to that desire is within the court's discretion. So moving on, these are the current factors that are laid out in the draft that are considered in determining whether to conduct this interview. So the factors include the likelihood that the interview will assist the judicial officer in adjudicating the covered proceeding, the child's age, maturity, and capacity to communicate with the judge, the child's expressed desires to communicate with the judicial officer. So there's that point that I mentioned on the previous slide. The benefit to the child from the interview, potential harm to the child from the interview, the availability and suitability of other processes to elicit the child's views, and the likelihood that conducting the interview may facilitate recognition or enforcement in another state or foreign court of the decision in the covered proceedings. And then any other relevant factors.
Mr. Chairman? Is the word child defined?
It is defined in the Act, yes.
And is there any off limits to where, I'm just trying to think of some examples maybe where you can't interview this child because of, I'm assuming they have to be, they've got to be mentally mature and not suffering from a disability, I guess, for lack of better terms.
So that's why we have, I believe I could find it. Yeah, child means an unemancipated individual who's under 18 years of age, or an adult who, because of physical or mental incapacity, is the subject of a covered proceeding. But so that's the definition. And the factors are what lays out when we take into consideration whether this is an appropriate proceeding for a child. So we take into consideration the factors layout. We would take into consideration the child's maturity and their ability to communicate effectively with the judge. Is that discretionary with the court? Yeah, this is all discretionary for the judge. So this just lays out guidelines for a judge to consider when deciding to proceed with the interview. Yeah, really the big emphasis that I saw when I was reviewing the draft was that it's the judge's discretion to move forward with this proceeding. Does that answer your question? Yeah. And then these were the previous factors to consider in determining whether to conduct a child interview. As you can see, the factors have been much more expanded from last year. And again, that's because the draft removed that presumption that the judge is always going to listen to the child, whether the child wants to talk to them. So now we'll move on to protecting both the child's interests and the due process rights of the parties. So this act balances two compelling but sometimes competing interests of protecting a child when that child's views are obtained by a judicial officer and protecting the due process rights of the parties by setting out a procedural framework that draws from a case law and statutory law. This framework gives the judicial officer discretion to further tailor the process to balance these interests. So again, big focus on judicial discretion throughout this act. The less formal conversation that may result from this type of interview means that contested factual information may surface during a child interview. And accordingly, this act includes provisions that ensures that a party's due process rights are respected when a child makes such contested factual allegations. The act recognizes that parties have the right to know information from a child interview that the judicial officer may rely on in reaching a decision, and also ensures that when a child makes factual allegations in the interview that may have a direct impact on the outcome, the parties have the opportunity to respond to such allegations. So the act recognizes that the child's attorney has an absolute right to attend the interview. And similarly, if the child has a guardian ad litem, that individual may be permitted to attend the interview. When a child has both an attorney and a guardian ad litem, the GAL's attendance is discretionary with the court. The act provides that parties and their counsel may not attend the interview in person, but the judicial officer may permit the parties and their attorneys to observe the interview remotely in real time and submit questions. So the judge retains full discretion regarding the questions to be asked. So that would just be if the judge feels that a question is inappropriate for the interview, he's not going to allow it to be asked. And the act requires that a record must always be made, and this is an update, so the 2024 draft contains options regarding whether a court must create a record of the judicial interview, and now it's just required. So the framework for proceeding after an interview has been conducted. So the draft now contains two alternatives regarding parties' access to the interview record absent stipulation. Both alternatives are structured to protect the due process rights of the party, and the alternatives account for differences in existing state laws. So alternative A provides for access to the interview record in the trial court and a right to submit evidence and legal argument and response before a final decision is reached. And alternative B provides for access to the interview record, unless otherwise stipulated, only on appeal of the issue before the court in the covered proceeding. So alternative A is a bit of a lower threshold since the parties have an absolute right to the interview record in the trial court, absent stipulation to the contrary. And both of these approaches have been upheld in appellate court as providing sufficient due process to parties, but they provide a policy choice for state legislators in the degree to which they protect the child's interest in confidentiality. So this is relevant Virginia law. This I did review last year. There have been no updates to any of these laws, but you can see that code already requires these interviews occur in certain instances, like 16.1-28.2.1. That's permanency planning hearings for children in foster care. So that just requires that in each of these planning hearings and in any hearing regarding the transition of the child from foster care to independent living, the court shall consult with the child in an age-appropriate manner regarding the proposed permanency placement or transition plan for the child, unless the court finds that such consultation is not in the best interest of the child. 20-124.2:1, in-camera interviews of a child record in any proceeding in a court of record to determine custody or visitation, when the court conducts an in-camera interview of a minor child whose custody or visitation is at issue, without the presence of the parties or their counsel, a record of the interview shall be prepared unless the parties otherwise agree. The record of the interview shall be made a part of the record in the case unless a decision is made by the court that doing so would endanger the safety of the child. So this is very similar to what the draft lays out in terms of making a record.
So Hannah, question for you is that does the act require a recording even if the parties stipulate that no recording is required?
Yeah, the act does require the record to be made. Okay. Yeah, so that's one of the biggest changes I think from the previous draft was the previous draft laid out alternatives and some of those allowed for a record to not be made, but this requires that a record be made. And then we have the Uniform Child Custody Jurisdiction and Enforcement Act. In most interstate custody cases, this act dictates which state will have jurisdiction for both an initial custody determination and a modification of a prior custody order. And this act is actually a product of the Uniform Law Commission and is relevant to the Judicial Interview Procedures for Children Act because the definitions are congruent. So this is the major difference between the proposed act and Virginia Code, although it's not necessarily a difference anymore. So the 2024 draft contained options regarding whether a court must create a record of the judicial interview that differs from Virginia Code, which have been removed from the draft. So our code stipulates that when the court conducts an in-camera interview of a child whose custody or visitation is at issue without the presence of the parties or the counsel, a record of the interview shall be prepared unless the parties otherwise agree. And option 2 from the 2024 draft differed because it merely provided that the judicial officers shall make a record and did not include language allowing parties to agree otherwise. Actually, I misspoke. So there is an allowance in the draft that includes language allowing parties to agree otherwise. So this would mirror our code. So the current draft does require that an interview record must be made and includes language allowing parties to agree otherwise. So that's similar to our code. So finally, last.
Hannah, it's Mary Devine.
Yes.
I have a question about all of this and the continued references to a record and how this really would work in Virginia. In the juvenile courts, there is no record, and the vast majority of these cases are going to be heard, at least initially, in the juvenile courts. And those judges are going to be the ones conducting or not conducting the interviews. And have you gotten any feedback from the Virginia juvenile court judges on this at all?
I have not gotten any feedback from them. I got feedback from one organization last year, and they didn't have super strong feedback about the act, again, because it's kind of set out as a guidance document. The act in the notes says, hey, this may be better as a court ruling. So I think that's why the organizations that I heard from last year were kind of like, well, we don't have super hard feedback on this, but I did not hear from anybody from the court system.
Okay. I just think, in Virginia, I know that they do conduct these interviews, but the requirement for a record, at least in the juvenile court, is not non-existent as far as I know. And this would change that, which would be a pretty significant change to the juvenile court process. So, I get it when you get to the circuit court, and I get it when you're talking about a child aging out of foster care, because that's not really a child anymore, and you do want to make sure you have a complete record for the permanency file. But I guess, and I know we're outliers in Virginia, I'm just having a hard time figuring out how we could make this work in Virginia.
Sure, yeah. Yeah, and I think that's why they suggest that in certain states this might not be proper for a legislative act, is because states differ in their processes and laws, and the act doesn't, the intention of the act is not to supersede any existing laws or processes. It's just to provide guidance to help judges in deciding whether to conduct these interviews.
Well, if this goes through the conference, and presumably it will, it'd be worth getting some kind of input from the Supreme Court and the Juvenile Judges Association as to what their feelings would be about it, because I think it probably in Virginia would be more appropriate for a court rule than a statute. But okay, thank you.
Absolutely.
Hannah, how critical is the record to this act if you removed all reference to that? Would that be so detrimental that it...
Yeah, I think the record portion is pretty critical to that opposing, like the balancing act that they describe, because certain facts can be discussed in this type of interview. Like an example they brought up in the comments in the draft is that a child in an interview could claim that his father hit his mother in the front yard with a baseball bat. And that's the kind of allegation that the parties would have a right to dispute and bring evidence for or against in open court. So they lay out, that's the critical importance of this record, is that it allows those parties to be able to contest factual allegations.
Well, the making of a record is going to be pretty important under this act. And,
yes.
And just because a court is one not of record, meaning it doesn't have a court reporter present all the time, doesn't mean there's not a way to make a record. I mean, it can be taken care of, but it does need to be discussed.
Yeah.
Mary is exactly right. I mean, we need to make sure that the judicial branch is on board with that requirement and how to meet that requirement. So, yeah. Thank you.
And the fiscal impact of that requirement.
So it sounds like you're already thinking about perhaps the good or bad ideas about this act, but I'll just review the last slide we have, which is whether this act is a particularly good or bad idea. So it does provide a framework for child judicial interviews that is not present in Virginia code, so that could be helpful for judges moving forward. It also provides guidance for judicial officers on when to conduct this child interview. As you saw, the factors that were laid out, it definitely sets out guidelines for them to consider. It could have an impact on the due process rights of the parties because of the potential impact of a child interview on the ultimate decision in the proceedings, but the proposed act does take steps to address this. And tracking the real-life use and benefits of the framework set out by the proposed Uniform Act may be difficult, as noted. Yeah, I think that was it. Yeah.
All right, any additional questions for Hannah?
Thank you very much. Yeah. Just a thought, maybe a comment to Amigo. When you're making these assignments, it would be, I think, really helpful if you could have the people that are doing the reporting think about fiscal impact and whether they think that the implementation of an act would have fiscal impact. And I know DLS doesn't do the impact statements. I guess it's still done at EPB, or DPB sort of ramrods. It's done in the agencies, or it used to be back in the day. But I think that would be real helpful to know, because that sometimes is a kiss of death. I mean, you can have the greatest bill in the world, but if it has fiscal impact, probably not going to get through.
Yeah, Mr. Chairman, I was just going to ask Hannah if you could maybe just reach out to Executive Secretary of the Supreme Court to just ask, because I think EM is right. If it has a big fiscal impact, then that'll be something that will probably drag it down. But just to get an idea of what they think about it.
Yeah, absolutely. Yeah, I can do that. I did reach out last year and I hadn't heard back, but I'm more than happy to reach out again. Yeah. Is there any other questions?
All right, if not, Hannah, thank you.
Absolutely. Thank you.
All right, next up, Lucas.
Hello, my name is Lucas Childers. I'm also an attorney with DLS. I currently staff the Senate Education and Health Committee. I am a lifelong Virginia resident. I went to Virginia Tech for undergrad and then Catholic University up in DC for law school. Prior to joining DLS, I practiced criminal law for about 3 years, and I've been here at DLS for about a year now. And today I'm here to talk about commercial financing disclosures. So commercial financing disclosures is somewhat of a vague term, and the reason for that is that because there are currently 9 states that have commercial financing disclosure laws on the books. All of those laws are different. They all apply to either different entities, different loan or financial instrument amounts, or different enforcement structures. So one of the benefits of the draft law that's been put forth is that it does bring uniformity to what these states and whoever else decided to join that Uniform Act would essentially be the same rules for each of these states. It's not necessarily one of the goals of the act, though, so the goal is too explicit. There are 2 explicit goals, and that is for merchants and essentially small businesses to be able to compare offers from different providers of loans and then different instruments from those providers themselves. Just to take, I guess, a brief step back, essentially what the big idea behind this is that there are a lot of regulations for banks and institutions that loan to these large corporations. And then federally, the Truth in Lending Act was passed in 2005, and that applies to the disclosures that have to be made to consumers, the APR, the term length, and there's still a gap in between those two. So if you're not a consumer and you're not a large business, there's a lot of these merchants or small businesses that essentially don't have any sort of disclosure requirements that apply to them. So the idea is to be able to get someone who's not necessarily an attorney who runs a business to be able to look at a small sheet of information and figure out kind of the bounds of whatever the financial transaction is. It does get a little bit trickier with commercial transactions because it's not as simple as a car loan or something that a consumer might sign up for. So what this draft act does is that it actually picks 4 types of transactions: the closed-end loans, which is essentially like a consumer transaction. It has money given to you up front. You have a term to repay that, and you're able to calculate essentially what the APR, what the interest is going to be over the life of that loan. An open-ended loan is just like a line of credit, so it can be a maximum amount that you're allowed to draw from, but you're not drawing it all at once, and so that affects how much you pay back and the timing of those payments. The other 2 types of transactions that this act applies to are factoring transactions, which is essentially either the sale or the loan of a company's accounts receivable. So if they have all of these open accounts, they know they're going to collect money on them eventually, then they can sell the right to collect that money to this lending company for an upfront payment. And then the last one is revenue-based financing. Revenue-based financing is particularly salient for Virginia because revenue-based financing is the one type of transaction that we do currently have a law for, which I'll get to in a minute. But basically, revenue-based financing is the idea that you take out a loan amount and then you elect to pay back that loan based off of the return that you get on your gross receipts. So essentially, if you take a percentage out of each time you make a sale or each week of sales. There's a certain percentage of that money that goes directly to pay back this loan. And what that does is that it changes the time that the loan gets paid back on. Sometimes that can be calculated pretty specifically. Sometimes, depending on the business, that can be a little bit more sporadic, which is one of the difficulties that this draft act does try and tackle is not only different instruments, but even among something like revenue-based financing, you're going to have different companies that do not have necessarily consistent income because they are typically small businesses. They could be seasonal. And so really it's trying to draw a balance between what works for the most amount of these merchants or small businesses. A couple of other important notes is that so this draft act would apply to transactions of $500,000 or less. That's, like I said, to kind of get the market of these merchants or small businesses. The transaction amount is actually equivalent to what's currently set for Virginia, but other states that have adopted these laws have varying amounts, anywhere from $50,000 to $2.5 million. So that is something that certainly changes depending on other states and how they weigh that amount of money. Another important part is that the disclosures are required at the time the offer is made. So this is not something that you get when you sign on the dotted line. It's whenever the offer is actually extended to you. And that again goes back to the idea that they're really trying to make it simple for someone who's not necessarily versed in accounting or law about what exactly that they can borrow if they're going to be able to afford it. And so they want to be able to make that available to them as soon as possible. Some of the things that the Draft Act does not apply to are purchase money financing agreements. So that's like a purchase money mortgage. Lease of goods also is not touched under the scope of this act. And then there's a small lender exemption. The Draft Act exempts lenders and their affiliates, which is just defined as a company that is wholly owned by another company. So they group them together for the purposes of this act. If they provide 3 or less transactions within a state within a calendar year, then they're also not required to make these types of disclosures. For the disclosures themselves, so closed and open-ended loans have the same disclosure requirements. So because those two are grouped together, there are really 3 separate, even though it applies to 4 types of transactions, there are 3 separate disclosure requirements. Each requirement that you see here that has an asterisk at the end of it, those are the same for all types of disclosures. So when I go over the next 2 as well, you'll see that these are identical. And so really the only ones unique to closed and open-ended loans are the total amount of the loan, and then the total amount that's dispersed if it's different, and then the total amount of payments to be made, as well as the dates of those payments, and then the final payment due date. The reason that these are different is not necessarily because different philosophy or anything, but just based on the instrument, different information is going to be provided to these companies. The one thing I would point out about here is number 6 and number 12 talks about an estimated percentage rate in an EPR calculation disclosure. So this is, the EPR is kind of the sticky wicket of this whole draft act. Is instead of an APR, your annual percentage, it's an estimated percentage rate. And the reason that they want to call it an EPR instead of an APR is because they do want to signify to these merchants and small business owners that it is different than an APR. And the reason it's different is from what I talked about before, how there can be seasonal businesses. So you have different arrangements where if it's a revenue-based financing, it may be a different calculation than if it's a closed-end loan, which you know exactly how much interest you're going to pay from the outset. And they want to signify that this is something that the recipient really does need to take a look at. This is different than what they're used to. And I guess one more note about that. So a brief example of how EPR can be vastly different is that in a closed-end loan, like I said, you know exactly how much interest you're paying. If it's a $100,000 loan and they tell you you have to pay back what's the equivalent of $120,000 over 24 months, you can calculate the interest rate based off of that time period, the 2 years. If it's a revenue-based transaction, then you're giving them a percentage of your revenue, which could obviously increase so much so that you pay back the entirety of that $20,000 in 6 months or a year instead of 2 years. And so if you're paying $20,000 on a $100,000 loan over the course of 6 months, your interest rate is going to look dramatically higher than if you're paying that off the course of 2 years. And so that's something that they've really tried to wrestle with in the drafting committee, is how to make that known before people sign up for these agreements. The factoring transactions that I mentioned before, again, they have the same 7 disclosures that were required for the open-ended and the closed-ended loans. And then they also have things that are unique just to factoring transactions, like the total face amount of accounts and the purchase price paid for those accounts, as well as the cost of the recipient. And those are the only ones unique to that. For revenue-based financing, like we were discussing, the total purchase price paid, the amount dispersed if different, the dates of payment, as well as the total amounts of payment to be made are just unique to revenue-based financing. And this here is an example that's included in the Draft Act of what one of these disclosures would look like. So it basically lists all of that pertinent information in one place. So it'll just be like a one-page piece of paper that hopefully a merchant will be able to look at, understand what their obligations are, and then even shop that around to different lenders. These are just some considerations that I think may come up at the annual meeting. So I started off with the EPR inclusion/exclusion. Really, the idea behind that is what I was talking about, where including the EPR can be confusing if it's not something that you understand well, because like I said, for a revenue-based transaction, it could look like you're paying well over 50% of an interest rate, depending on how quickly it's paid back. And so there is some concern that including numbers like that in a transaction like that will do more harm than good. But it seems like where the drafting committee has landed is that the EPR itself will be included even in those types of transactions. The calculation for those transactions is a little bit more up in the air. So that is something that's based off of what your estimated revenue is going to be. With a lot of these small businesses, it's not something that can be just extrapolated from your past 6 months, your past year, your past 2 years. It's something that can change. It's variable over time. And so that's something that I still think does need to be hashed out before this will go up for consideration. The enforcement alternatives I included here. This is something it's really unique to how these other 8 states and Virginia decide to have enforcement actions for people that violate this law. Some states have a situation where they'll have a certain arm of their government that does all sort of enforcement for fraud or other cases that involve consumer finances. There's 2 separate alternatives in the Draft Act to either incorporate that system or, if that system is not already in place, to kind of replace it with one of its own. With Virginia in particular, the remedies are, they're not vast in Virginia. We basically have the SCC. They can basically recoup any sort of fees that were extended if there is a violation of our law. And then it also gives the power to the Attorney General to enjoin any sort of agreements that they believe are a violation of our current code. The small lender exemptions, I also think, is going to be up for consideration. So if we go back to the scope of the exemptions here, it says that the lenders plus their affiliates that provide 3 or less transactions within a state in a calendar year. The calendar year portion, as well as the number of transactions, they landed on 3 right now. That's been debated back and forth throughout the drafting process. It was initially 5 within a 12-month period. The 12-month period got a little bit tricky because of the types of these transactions. It's hard to exactly say when they were commenced or if they were renewed. Does that count as a new agreement? So what the draft does, it just says it's a calendar year within a state. It's a lot cleaner that way. I think it'll probably work better in practice. The reduction from 5 to 3, that's something that the drafting committee just kind of went back and forth on. They've landed on 3. Although I will say most of the current states that have these laws are 5 within a 12-month period. The Virginia law itself, so they have Chapter 22.1 of Title 6.2. It's just called sales-based financing providers, but sales-based financing is the exact same thing as revenue-based financing with a different name. The open-ended loans, the closed-ended loans, and the factoring transactions are just not addressed at all in Virginia. So really that's where the difference would be. The largest difference would be just having these brand new laws applying to those 3 types of transactions. The scope of Virginia is exactly the same as the Draft Act as far as the amount of money goes. So it's $500,000 or less. You would have to provide these disclosures. What it is exempt in Virginia are financial institutions, which are defined as a bank, trust company, saving institution, industrial loan association, consumer finance company, or credit union. That's very similar to what the Draft Act exempts, which are depository institutions. It is a slightly more expanded definition, but it essentially conveys the same idea, which is that if there are these institutions that provide tons of these loans that are probably multinational corporations, they typically have a higher level of regulation, and it's not what this act is trying to address. This act is really trying to address predatory lenders who take advantage of there not being regulation for the size of their loans right now. The current Virginia law also exempts, like I said before, it's the small lender exemption of 5 sales-based financing transactions within a 12-month period. If we go to the next slide, I have the disclosure requirements. These are all almost identical to the Draft Act disclosure requirements, slightly different verbiage, but the numbers are almost exactly the same. The one thing that Virginia law does not have is that EPR calculation that I was talking about. The EPR is, it's definitely a newer idea, and it's definitely like the largest divergence, I would say, between most of these state laws and the Draft Act itself. One thing I will say about that, though, is that Virginia they kind of tackle the hardest issue about EPR, which is getting that projected sales volume. Number 4 in the disclosure requirements is the estimated number of payments based on projected sales volume. That projection itself is the tricky part, but Virginia does already address that with the disclosures that they make. And then this is just a brief overview of the differences between our current law and the Draft Act. As I said, the only overlap right now is the revenue-based or sales-based financing, and the scope of the transactions that require these disclosures. Depository versus financing institutions are almost identical. That will not be difficult to reconcile between the two. The frequency criteria, so the 3 in a 12-month period or 3 in a calendar year versus 5 in a 12-month period. That's the frequency criteria that's currently different, but it's not off by a lot. And then the inclusion or exclusion of affiliates for that small lender exemption. That is one part of the Virginia law that is not, the Draft Act, I think, does a really good job of essentially closing a loophole. So what some of these lenders can do is essentially they can reach their reporting requirement. They can have their 5 transactions in a 12-month period. And then instead of making that 6th transaction, what they'll do is they can just have a separate company which is totally owned by that first company, and that separate company can then make 5 more transactions. And so you can actually get into just an infinite loop of these new companies that are made just to make these transactions, just so they fit within that small lender exemption, and then they never have to meet these disclosure requirements. That's the only difference within the scope itself. And then, as I discussed before, the requirements that are required to be given are almost identical, except for the big one, which is the EPR. So really, if we were to incorporate that into Virginia law, it would be about how to incorporate the EPR and how it would be calculated. But beyond that, it wouldn't be a large divergence from what we currently have. And that's all I have on this act. I'm happy to answer any questions about this. It's kind of a big subject.
Any questions? Lucas, one question for you. I mean, the difference between the EPR and the concept of disclosure, which is more important in your view relative to what you've done research-wise to this act? Virginia doesn't have the EPR, but if the drafting committee's view is that's the most important thing, it's something for us to consider. I'm just curious where your views are on that.
Sure. Well, so the EPR is something that was debated within the committee itself. It's not something that they all agree on, but it does seem with their last draft that it is something that they've landed on. At this point, it seems like it will be included. The current Virginia law does not have EPR, as I said, so they do still have these disclosures without an EPR. So in a way, I don't think it's necessarily fundamental to the law to include that EPR, and some would say that it's actually going to be confusing to include that. So it's definitely possible to have additional information provided to these recipients without the inclusion of the EPR. And considering Virginia's current law, it may be easier to reconcile that currently.
Okay, any questions from online for Lucas? And if not, last call at the dais. Lucas, thank you. Go Hokies. And appreciate your presentation.
Thank you very much.
Okay, Caitlin and Michael. All right, the floor is yours. If you'll both introduce yourselves at the beginning, like we've asked everyone else to do. Tell us a little bit about yourself, where you went to school, how long you've been with DLS, even if it's only been for a few months, and what areas you work in.
Hi, I'm Caitlin Cooper. I am a Ryzen 2L at Wake Forest University School of Law. I went to undergrad at Washington and Lee, and then spent a few years working in Arlington for a government affairs firm.
Hi, my name is Michael Lindemuth, and I'm currently a Rising 2L at the University of Richmond School of Law. I completed my undergrad at Virginia Tech, so go Hokies, and I've been with the DLS for about 3 or 4 weeks now. So,
great, thank you both. Floor is yours.
All right, so I just wanted to say thank you all again for taking the time today to hear about all these different acts and presentations. And to get started, we're talking about child digital entertainers. So to begin, this slide presents 2 examples of child digital entertainers to help illustrate the types of individuals who could be affected by this proposed act. On the left is Ryan Kaji, who began making YouTube videos at just 3 years old. His channel, Ryan's World, features him playing with toys, conducting science experiments, and making crafts. And by 2020, he was reportedly making $30 million annually, and he now has his own toy line in major retailers like Walmart and Target. And on the right is a photo of Ruby Frank and her family. She was the creator of a now defunct YouTube channel called The 8 Passengers, which was like a popular family vlog channel. And this channel showcased the lives of her 6 children, amassed over 2.5 million subscribers, and they had around 1 billion total views on YouTube. And the income from the channel was reportedly directed by Ruby Frank, and there is no public indication that the children received revenue directly from her. Sadly, in 2023, Ruby Frank was charged with multiple counts of aggravated child abuse following an investigation into the treatment of her children, and authorities found evidence of both emotional and physical mistreatments. So these 2 cases represent kind of the extremes of this issue, one of enormous success, the other of serious exploitation, and together they show why lawmakers are asking what protections are in place for child digital entertainers. So moving on, I'm kind of going to discuss the historical protection of child digital entertainers. Historically, legal protections for minors in entertainment have focused on traditional mediums like film and television, but only recently have lawmakers begun extending those protections to the digital space. The foundation for many state efforts is the Coogan Act, which originates from California, which was enacted in 1939, and it was developed in response to concerns that child actors' funds were being misappropriated. The act requires a portion of child performers' earnings to be deposited into a trust account, which becomes accessible when the child reaches the age of majority. And so building on that framework, Illinois and California have passed legislation applying similar protections to child digital entertainers. These laws require content platforms or guardians to set aside a portion of the income earned by minors from digital content, such as influencers or social media work, in a trust fund. They also include provisions governing parental management of a child's digital presence and earnings. And then when we look at Minnesota and the legislation that they've enacted, they have adopted a comparable trust provision, but they also added a privacy component, which allows minors aged 13 and older to request permanent deletion of content featuring them. And the platform is given 7 days to comply, although the statute does not really have like an enforcement mechanism to really enforce this. And more broadly, around a quarter of United States or US states have considered or enacted legislation addressing child digital entertainment, and there is no federal framework governing this space. So this leaves us with a patchwork of laws, with some states, including California, Illinois, and Minnesota, expanding Coogan-style protections to the digital sphere, while others have yet to act. And these developments form the backdrop for the Uniform Law Commission's exploration of a model act, aiming to provide greater consistency and clarity for states considering regulation in this emerging space.
It's really a stupid question.
Yes, sir.
Does digital include TV? Would this apply to Leave It to Beaver?
It does. I have the definition of digital entertainment content means content that uses artistic, creative, or life story services, which you'll see is defined by the Uniform Law Commission on the next slide, including but not limited to video, image, or audio files created by a digital entertainer and shared to an online platform by or at the discretion of a digital entertainer in exchange for or attempted exchange of financial compensation or other non-tangible property or services of monetary value.
If I may, Mr. Chairman, just for background for the younger people, Leave It to Beaver was a popular sitcom from the 1950s.
I actually watched it.
It still is on MeTV.
All right, so moving on to some of the kind of background definitions that underlie this act. So firstly, the Uniform Law Commission's draft kind of follows the Illinois-California model. So that means there's not a privacy component to this approach. And so a central term in this draft is child digital entertainer, which is defined as a minor who provides artistic, creative, or life story services for digital entertainment content created by a digital entertainer. And the definition is intentionally broad and includes what the act refers to as artistic, creative, or life story services. And these are services provided by an individual acting in roles such as actor, dancer, musician, comedian, singer, or voiceover artist. But it also includes work that's more behind the scenes, like songwriting, producing, directing, choreography, and design. Importantly, the definition also captures content based on an individual's life story or likeness. That includes the use of a minor's voice, appearance, or personal story in digital content, so even if the child isn't acting in a traditional sense. And the goal here is to ensure that the draft can account for the wide range of roles that minors play in online entertainment, from featured performers to the subjects of family vlogs. Moving on, we have some more definitions. And so the draft also defines two key terms that help establish who is creating content and who may be responsible for involving children in that content. So first we have digital entertainer, which is defined as an individual 18 years of age or over, family, or other person that creates digital entertainment content. This definition is meant to capture the range of adults who produce or oversee content involving children, whether they are parents, relatives, or third-party content creators. And just important to note, there might be some future refinement in future drafts to clarify the phrasing, particularly the structure around age and relationship. And then next, the draft also defines a family member broadly to include not only parents, siblings, and grandparents, but also step-relatives, legal guardians, and others recognized as having a familial or custodial relationship under state law. This expansive definition reflects the variety of family structures involved in digital content creation, particularly in family vlogs or lifestyle channels. And while this definition draws from existing state-level language, it's worth noting that some jurisdictions, such as Virginia, use more detailed formulations of family member in their code, and these typically include both biological and non-biological relationships, including cohabitants and legal custodians. Carrying on, before we get to the major contents of the language of the act, I wanted to go over some of the exclusions and who this act does not apply to. So first, it does not apply to minors who appear in content that is not considered digital entertainment, which would be like a casual social media post. For example, if a parent or a family shared a family photo or video and they're not seeking or receiving financial compensation, the act would not apply. Second, the draft does not impose any new duties on online platforms. This model legislation is directed at the relationship between children, families, and the revenue generated from content, not the platforms themselves. And third, the act does not affect minors who independently create their own content, such as a teenager managing their own channel, as long as they receive no more than incidental help from someone over the age of 18. So in short, the draft seeks to regulate commercialized involvement of minors in digital entertainment, not incidental or non-commercial appearances, and not the platforms hosting the content.
Mr. Chairman?
Sir Lane, go ahead.
Thank you. Sorry to interrupt. Does it cover athletic contests? Athletes, young athletes. Right now, NIL, name, image, and likeness, is moving into the high schools and even junior high schools. And if it does cover it, I'm concerned, or I'm wondering how it interacts with both our Uniform Act on NIL and state laws on NIL. Do you know?
Sir, the digital entertainment content can be featured on an online platform, and the Uniform Law Commission in its draft defined an online platform in various capacities, but one being a streaming service, paid subscription, or internet access service on which a person can share content. The sports ramifications were not discussed at the informal meeting about 2 weeks ago, but this is the first round of drafts. Recently, that we just received late Friday afternoon, the most recent version of this draft, and there's been no talk, but you might hear some of that at the annual meeting coming up. But as of right now, nothing's been said outside of this online platform definition.
Okay, thank you.
And do we have any more questions before I move on to the rest of the act?
No, go ahead and proceed. Thank you. Thank you, Lane.
Great. So the draft the draft provides 3 separate pathways by which a minor may be deemed to have engaged in digital entertainment content and thus qualify as a child digital entertainer under the act. This slide outlines the first pathway, which is based on a quantitative earnings and exposure threshold. Under this method, 2 requirements must be met. First, at least 30% of each monetized piece of content within any 30-day period must feature the child's name, image, likeness, or other personally identifiable information. And second, either the content must meet the platform's financial threshold for monetization, or the content creator must have actually received at least 10 cents per view from any and all sources. And to support this, the draft includes a computation method. So for videos, the child's identifiable presence is measured by screen time relative to total runtime. And for non-video content like a photo, any identifiable appearance by the child is considered to constitute 100% inclusion. And these criteria must be met at least once during the calendar year for this pathway to apply. And again, this is just one method by which a minor may qualify under the statute. The following slide will address the other 2. And so there are 2 additional ways a child may be deemed to have engaged in digital entertainment content, each focused on total revenue generated over a defined time period. The second method looks at a 30-day gross revenue, and a child qualifies if the digital entertainer receives or is entitled to receive at least $2,500 in gross revenue from any and all sources within a consecutive 30-day period, and at least 30% of the content earning that revenue features the name, image, likeness, or other personally identifiable information of the child. And the third method uses an annual threshold instead, and a child qualifies if the digital entertainer receives or is entitled to receive at least $30,000 in gross revenue over the calendar year. And again, at least 30% of the content includes the child's name, image, likeness, or other personally identifiable information. And these pathways are designed to capture situations where content featuring children may not meet a per video threshold, but they still generate significant income over time. And with that, I'm going to pass it over to Caitlin for the rest of this presentation.
Okay. I'd just like to note that in the most recent draft that was issued on Friday, a lot of these concepts are going to remain the same as the drafting committee is floating around different ideas. So most of what you've seen so far is the same. This is one difference, though, how the funds are distributed to the trust. In the original draft, the drafting committee provided 3 different alternatives: by piece, by 30-day period, or by calendar year. In the most recent draft provided by the ULC, they got rid of the by calendar year, so now it's just down to by piece and by 30-day period. The actual trust is created in one particular way by the parent or guardian or individual with custodial control, but who is the trustee of the trust depends on who the digital entertainer is. If the digital entertainer is the parent of the child, then someone else must serve as the trustee of the account. However, if the digital entertainer is not the parent, then the parent must serve as the presumptive trustee. In terms of how we enforce this model draft, it's through civil action. So there are 2 ways in which a child digital entertainer can come forth when this provision has been violated. One is when the child is still a minor, they can bring suit acting through a next of friend, or they can bring it after obtaining age of maturity 3 years thereafter. So that's the statute of limitations, if you will. There are 4 means of relief: actual damages, including compensation that's owed, double damages for knowing or reckless violation, the cost of the action, including attorney's fees, and injunctive relief. Now I'm going to get into Virginia law as it stands. This year, actually, Virginia enacted HB 2401, which is now Chapter 699, and it was provided by Delegate Jackie Glass, and it was signed by the governor. And so just a little bit of history about the bill as it stands. You'll see as we continue that it's very, very similar to the ULC's model draft. One difference, and that's kind of why we see the vote differences up at the top. So the House had more contention when they passed this bill versus the Senate, and that's because the House wanted to add that provision highlighted in bold, which basically says that individuals created in content creation are going to be deemed employed, permitted, or suffered to work when they are engaged in hazardous working conditions. This really has no basis going forward as we consider the model draft. It's just something that Virginia wanted to add to its own code. Governor Youngkin did submit an amendment in the nature of a substitute. He wanted to create a working group to study this particular issue, child labor laws in the area of digital content creation. However, it was passed by for the day in the House, but yet Governor Youngkin signed the bill anyway. And so I'm just going to go through the differences between HB 2401 and the ULC's model draft. The first is how we define a child digital entertainer. So under the ULC, it's someone 18 years of age, like younger than 18 years of age. However, under Virginia, we've defined it as under 16 years of age. Additionally, there is no requirement within the definition of content or content creator for a child that relates to artistic, creative, or life story services requirement. That's only we see in the ULC model draft. As I previously mentioned, oh, sorry. Yes.
Question, do you have any idea why 16 years? That's sort of, I mean, I would think 18 makes much more sense than 16, but do you know any of the arguments about that?
I do not know any of the arguments. What I will say is that it is interesting because all of the times where the trust is created and when the child has access to the trust and when they can file suit on violation of this act all stems from the age of maturity at 18. So why 16 years of age is picked when all of the rest of the Virginia Act has it at 18 is interesting. I will say that it does protect individuals less than it would than the ULC model draft does because it encompasses 2 more years that someone could be earning income through a trust account. Is that okay? Okay, great. And then the timeline for determining whether a child is considered to have engaged in that content creation, which is those 3 different alternatives that Michael broke down, is the current calendar year for the ULC, but the previous 12 months under Virginia. And then similarly, those different alternatives on pages 7 to 8 of the PowerPoint slides, the model draft has those 3 alternatives, but Virginia only has one, the very first one, that's broken down into 2 components. Additionally, the ULC model draft considers what what the child should have been owed or should have received. Virginia does not consider that, only what they were compensated. Additionally, the ULC model draft has what now is the two, gross earnings by piece and gross earnings by 30-day period. Virginia just has gross earnings by piece. And then in Virginia, there's no one who must create the trust. They don't outline who the individual must be, as under the ULC, where it must be a parent or other individual having custodial control. Then when we come to civil action, as I already mentioned, under the ULC, the child digital entertainer can bring the suit while they're still a minor through a next of friend, or within 3 years after attaining the age of majority. In Virginia, it's pretty much the same, except it's only 2 years for that statutory limitation period. Additionally, you can only bring suit in Virginia with known or reckless violations, so it's a stronger burden of proof to meet in order to bring such a suit. Additionally, the remedies available in such a suit are less in Virginia. So we have compensatory damages, punitive damages, and the cost of the action. However, there's additional damages that can be earned under the ULC model draft if there's known and reckless violations. So you get those remedies are available to you regardless of whether it's known or reckless, additional if there is known or reckless violations. And then from a constitutional perspective, the drafting committee has felt there are no real constitutional challenges to this issue or to this bill. The only thing that could potentially come from this are the privacy provisions that we saw with the earlier Minnesota model to this type of act. However, the ULC purposely didn't add that privacy provision to this model act for the constitutional conundrums that might come up. And additionally, the concern would be, does it prohibit or take away some of the substantive due process rights of parents in getting to have freedom over their child and what their child does? And even if that were to have come up, the Supreme Court would likely say that that was intermediate scrutiny and that they've already ruled that that the parent's rights are not superior to that of the child in terms of its well-being. And so in the context of mandating school or child labor laws, the parent's desires are subservient to that of the child's. Additionally, in those privacy provisions, is there a concern that this is within the home, that the parent's rights are being infringed upon within the home? And in the case of Prince versus Massachusetts, the Supreme Court declined to let the presence of a child engaged in violative labor stand, even though it was in the presence of a guardian, and in support or advancing the family's religious beliefs. Any questions?
It seems to me injunctive relief is pretty important here, and Virginia does not provide for that. So what is your thought about that? I mean, it seems to me you wouldn't want an ongoing violation to occur until all the damages were racked up, and then you bring a lawsuit. You'd want to correct the conduct of the guardian or the trustee, right?
Well, injunctive relief is one of the biggest differences between the two versions. There is something to be said for the fact that the versions are so similar. However, it will be important to see what the ramifications of HB 2401 are in Virginia in order to see if we're really missing a key component, which is that injunctive relief, in tackling this issue and what the bill was intended to deal with.
Really,
Can I
just
ask a question? To follow up on that?
Ellen, please go ahead, and then after you, Tom has a question.
Oh, that was Mary.
Oh, I'm sorry, Mary. I wasn't looking at the screen. My apologies.
Nope, that's fine. I guess my question is, does the fact that the Virginia statute doesn't specifically mention injunction actually preclude the use of an injunction? Weren't these just the specific legal civil remedies that were specified in the statute, and that an injunction would be available as equitable relief is generally available?
In the ULC model draft, it includes injunctive relief under the civil relief, like it is a civil action. So they didn't parse those out as two different things.
Right.
So it would be probably if Virginia wanted to go forward with the ULC model draft, they'd have to amend the Virginia code to include the injunctive relief aspect to that.
But I guess that's my question. Would they? Is the fact that injunction isn't specifically mentioned in the Virginia statute, would that actually preclude someone from asking for an injunction in the proper case?
The first thing I would say,
not just asking, but also getting one, I guess, is more important.
the first thing I'd say is that the bill and the bill's enactment is so recent that we don't have any data with which to pull from as to how many people would bring suit under injunctive relief only compared to the other remedies that are available. Additionally, there was very little comment when the bill was going through chambers related to remedies. The only thing that anyone submitted testimony on or talked about was the hazardous provisions that the House wanted added to the conference committee report. And so for that reason, I'm not sure how much injunctive relief really mattered to the delegates when they were considering this particular bill.
Okay, thank you.
You're welcome.
Tom.
Just a point of information, I've signed up as an observer to this drafting committee. All drafting committees are a bit of a moving target, but this one is a moving target in another dimension. The Uniform Transfers to Minors Act is also being revised, and the thought is that to the extent that this is setting up a trust account for a minor, the aim is to try to coordinate this act and its terms with what will be the new Uniform Transfers to Minors Act.
Thank you, Tom, for that observation.
And it's only on first reading, so that can still be done. Good.
Any other questions for Caitlin or Michael? So, Caitlin, what's your view relative to this act and current Virginia law as to which one, I don't want to say maybe better, but is there an advantage to the Uniform Act that's not present in what was just passed?
Well, the advantage to the Uniform Act is that it encompasses and protects more individuals. You have 2 more years added to a child's age that's protected. You also have more ways in which someone is deemed a child digital entertainer under the ULC model draft. And there is the provision of injunctive relief. So I think the question is the benefit of those provisions and the protection they bring worth putting forth another bill to amend the Virginia Code?
Typically in Virginia, when you just enacted something, it's very hard to amend it right away without having a little track record. And it's going to be another, 2 years before this thing gets out of the blocks anyway. So maybe there will be a little history and by that time to be able to make a few minor amendments to the act.
Okay, any other comments? If not, thank you both. Excellent presentation. Very much appreciate it. Okay, Casey.
Amigo, I hope you tell everybody, all these staff people, because they're leaving after they make the presentation, we can't give them a applause at the end, but they've done an excellent job. Incredible.
Because I have them working so hard, they have to get right back.
I know. I saw your whip down there. That's brutal.
I'll make sure that they know.
All right, please introduce yourself.
I'm Casey. I am a native Virginian, so I went to law school at the University of Colorado. I graduated last year, and I'm excited to be back in the Commonwealth and present to you today. So today we're, last but not least, talking about occupational licenses of service members and military spouses. This clicker. So a little bit of background, the study committee on this Uniform Act was actually formed back in 2022, and there was some movement in Congress on this subject specifically. So in January of 2023, Congress passed Title VII of the Service Members Civil Relief Act, which I will be referring to as the SCRA. The study committee recommended the creation of a drafting committee after this passage in November of 2023. Then Congress further amended the SCRA. And so today we are looking at a draft that is the culmination of all of these different timelines here. And just to be clear, we're talking about 3 different pieces of legislation. So we're talking about the SCRA, which is the federal law, the Uniform Act, and then I'll be talking about Virginia law as well. But if you have any questions on what I'm talking about throughout this, please stop me. So the purpose of this Uniform Act is to support military families by making it easier for service members and military spouses to get state occupational licenses when they're forced to relocate due to military orders. And a secondary kind of purpose of the Uniform Act is to smooth this implementation of the federal SCRA. The overview of the Uniform Act, I'm going to hit 5 points here, and then I'm going to go into a little bit of the structure of the Act. But just at a high level and comparing to the federal law, it first requires licensing boards to issue a license to a service member or their spouse or domestic partner if the state adopts domestic partnerships, who possess a license from another state as long as they can provide proper documentation, which are military orders, a marriage certificate, and a notarized affidavit that basically states they are who they say they are, their license is in good standing, things like that. The SCRA simply guarantees that an out-of-state license is valid rather than requiring state boards to issue licenses, so that is a main difference that I want to highlight up front. Secondly, the Uniform Act requires licensing boards to process applications within 30 days. And if that deadline can't be met, they must issue a temporary license while the application is being processed. This is included in the SCRA, but it is a may issue temporary licenses. So again, this is another gap filled by the Uniform Act. So next, third, the Uniform Act provides that licenses issued under the Act are valid for the duration of a standard license issued by a state licensing board, and they are renewable for as long as the military practitioner remains in the state under military orders. Fourth, the Act specifies that licenses issued to service members and their spouses under the Act shall operate the same way as other occupational licenses, except that they're meant to be temporary. And fifth, the Act imposes information sharing requirements on state licensing boards with the aim of making it easier for service members and their spouses to obtain new licenses. These 3 points are only in the Uniform Act and in the Federal Act, as opposed to the Federal Act, not as opposed to state law. But in the Federal Act, there's also a provision allowing boards to conduct background checks, and it also exempts licenses included in interstate compacts. We have a few of those in Virginia. Examples would be social workers, PAs, EMS personnel, cosmetologists, and dentists. So those interstate compacts already exist and have some interjurisdictional reciprocity. I believe the bar is mostly state by state. But there isn't a compact in Virginia law that I'm aware of.
The only reason I think it does, I was on the study committee for this, and I voted against going forward with it because of federal, I thought it was, the majority of it was federally preempted. And I did check with the bar, and I always thought that Virginia only gave reciprocity for states that gave reciprocity to us, but I'm not sure that's the case anymore in my discussions with them. Tom, do you know what's going on with that?
Well, does this apply to any and all licenses of any kind or description, or are there some exceptions?
So they apply mostly to licenses where you need a license or a certificate or registration legally to perform work in the field.
Yeah, but that's pretty broad.
Casey, to Tom's question, is this things otherwise regulated by a state's Department of Professions and Occupations, meaning variety of mechanical trades and things of that nature, or is it broader than what would otherwise be regulated, like real estate license, HVAC repair, or does it go to like dental hygienist and a variety of other things? Do you happen to know?
So in the Uniform Act, it does I think in Virginia, it's easier to think of it as anything kind of covered by the Department of DPOR, Professions and Occupations. But let me find the definition of license for you. So in the Uniform Act, license means a license, certificate, or other evidence of qualification that an individual is required to obtain before the individual may engage in or represent the individual to be a member of a particular occupation or profession. So anything in a state that you would need a license or certificate in order to perform the work. Pretty broad, yes.
If I may, Mr. Chairman, I think the way when it was first introduced in Virginia, I think I may have worked on the legislation, which is, but it was really Title 54.1, and you're talking about DPOR, you're talking about health professions, and there was some pushback because the state licensing boards want to have something to keep it from just being automatic. But that's been a while, you know. But there was that was typically what the legislation covered, DPOR and DHP, health professions for the most part.
But that definition in the Uniform Act doesn't sound like there are any exceptions. I'm just curious to how that was worked out that way. I can't imagine there weren't plenty of observers who would have had questions about that. And do states, even in the area of the kind of licenses that have just been mentioned, covered by the Department of Occupational Licenses, whatever it's called, are there significant substantive differences in the states for who can qualify and how they qualify? Because I mean, this just seems like a huge issue to me.
So I would imagine that sometimes there would be differences in state-by-state licensing. One provision that I'll get to a little bit later is the licenses must be substantially similar, if that's helpful. That is not defined in the Act, but that leaves some room for state boards to have a little bit of autonomy in the kind of licenses that would fall under the scope of the Act.
Well, a state like Florida, for example, which has no reciprocity with anybody in terms of a legal license, I mean, I just can't imagine that they would, all these retirees retiring to Florida and wanting to practice law, or in the case of a military person being transferred to Florida and just being able to appear in court the next day. I can't imagine that's going to work.
It's definitely a broad scope. I'm going to truck on, and hopefully that will answer some of your questions and maybe narrow it a little bit. But going through the structure here, this is laid out pretty much section by section. There's a title section before this and a couple of sections at the end relating to severability and other state-by-state differences. But this is the meat of the Uniform Act. So first, as I mentioned, the definition of license is intended to capture other things rather than just licenses, so certificates, registrations, and other legal grants of authority that are required to work in a given field. Board, license in good standing, professional practice standard, and scope of practice are also defined. If you have any questions on those, I will define them as I get to the professional practice standards and scope of practice later on. But the scope applies to both service members who may sometimes have second jobs and military spouses. So getting to the actual licensing, as I mentioned, the Act requires the issuance of a license in the new state as opposed to just saying that under the federal law, the license is valid. Boards shall create the application processes and impose a 30-day turnaround. Otherwise, they must issue a temporary license. And the out-of-state license must be substantially similar to the license being applied for in the new state. This is just a comment in the Uniform Act, but states may have differing fee structures. The goal of the act, again, this is a comment, the goal of the act is to minimize licensing fees to service members and their spouses. There's nothing in the act that addresses fees, but it's noted as a point of movement or consideration. As for duration and renewal of these licenses, the licenses issued under this act are valid for the same license cycle or duration as other licenses in the state, and they're renewable for as long as the military practitioner remains in the state. The same professional practice standards and scope of practice applies to military license holders under this act as to regular in-state license holders. Again, those definitions, professional practice standard includes a standard of care, a standard of professional ethics, a practice requirement imposed by a board, and scope of practice means the parameters of various duties or services that may be provided by an individual under a license. Same with disciplinary action. Boards are authorized to discipline military license holders in the same manner as regular license holders. And finally, reporting, designated individual, and coordination. This is, the Uniform Act states that boards should require annual reports with the legislature and the governor, and the reports include the number of applications, the average processing time for an application, the number of licenses, the number of applications, reasons for the denial of an application, and for each application that took longer than 30 days to process, an explanation of why. That's just an idea of the annual reports under the Uniform Act. The Uniform Act also states that boards should designate points of contact for service members and military spouses to publicize information regarding the act so that it can be utilized. So getting into the comparison to Virginia law, we have one section in code that is most analogous to the entirety of the Uniform Act. This section states that application review of these licenses must be completed within 20 days instead of 30 days. It also has a substantially equivalent language, very similar to the substantially similar language in the Uniform Act. It still requires, I realize that's not in this slide, but it still requires the issuance of a license, unlike the federal law. Boards may require any documentation it deems necessary. That is a departure from the Uniform Act where specific documentation is required, like those military orders, the marriage certificate, and the notarized affidavit. The Virginia law only applies to military spouses and not service members, while the Uniform Act also covers service members. And then as far as duration goes, temporary licenses, those temporary licenses where the application review is not completed within 30 days, then the licensee is given this temporary license. Those are limited to 12 months. Otherwise, there's no real duration or renewal period specified, whereas in the Uniform Act, there are clear provisions on the scope and professional practice and duration renewal and disciplinary measures. So the Uniform Act is just a little more robust in that background kind of sense.
Can you back up to the prior
Of course.
slide?
This one? Or this one?
That one about the board's reporting, yeah. I mean, that'll raise a separation of powers issue of some sort because the bar is controlled by the judicial branch and the legislature and the governor. It would be the Supreme Court that would want to know how many bar members there are and what they've paid in dues and that sort of thing. So I guess I can't imagine they intended to include things like medical and law licenses and things of that sort. But from what you've reported here, it looks to me like it's completely open-ended. We'll have to learn more about that. I'm sure we will at the meeting.
So as far as exemptions go, there are none in the Uniform Act, but in the federal SCRA, that initial version of it in January of 2023 did exempt lawyers and interstate compacts because they're already covered. But the lawyer exemption was actually taken out of the federal law, so that probably was considered by the drafting committee. I don't have any information on why they didn't include that, but just as a little bit of a background.
Well, we probably unfairly hit you with all this because I didn't expect you to start this scheme up or through the same.
Of course.
Hey, Tom, it's Mary.
Go ahead,
And
Mary.
I don't know if this is what the ULC drafting committee is trying to do or not, but they talk about the out-of-state license having to be substantially similar to the license in this state. And I guess they may suggest that you can argue that a North Carolina bar license is not substantially similar to a Virginia license because you pass the North Carolina bar, not the Virginia bar. And if you can make it under reciprocity, then this Uniform Act wouldn't apply, correct?
I think that's a good argument.
Maybe the drafting committee is just trying to thread the needle. I suppose doctors have the same problem, but maybe the drafting committee just didn't want to raise a flag for lawyers helping lawyers. I don't know.
All right, moving on to a couple of other relevant provisions of Virginia law. There is a military spouse liaison in code. In addition to some other outreach and advocacy roles, the liaison provides assistance and information to military spouses seeking professional licenses and credentials or other employment in the Commonwealth. This is, of course, one role in the Commonwealth, but it does cover some aspects that the Uniform Act covers, like designated points of contact for service members and military spouses. In the Uniform Act, that suggests that there are multiple roles that might be within boards. But again, the Uniform Act goes further as to say that there should be more reporting requirements as far as boards go with respect to the application processes. One point on this military spouse liaison section, it was amended in 2023 to remove annual reporting requirements, just a consideration in terms of that difference in Virginia and Uniform Act law. And then finally, 54.1103, boards may promulgate regulations or enter into agreements with other jurisdictions to recognize out-of-state licenses. This has been around for a while, but this just kind of covers some of those compacts, and it's kind of adjacent to what we're talking about. The Uniform Act doesn't, as I mentioned, does not address interstate compacts, but the federal SCRA specifically exempts them. This is a summary of the remaining differences between the Uniform Act and Virginia law. So I think the biggest one is that Virginia law only covers military spouses and does not include service members. Although I will note that the Virginia law does cover spouses when the service member has left active duty within 1 year of application, which the Uniform Act does not cover. There are no specific definition section in the Virginia Code, but the Virginia law also leaves required documentation up to each board, while the Uniform Act requires specific documentation, as I mentioned. The Uniform Act is more specific on duration, renewal, the equivalent nature of professional standards and disciplinary actions in those sections that are not specifically addressed in that one section I covered first. There is a military spouse liaison, but it is only one person, while the Act suggests points of contact within boards. And those reporting requirements, again, were in code, but were taken out not too long ago. And one last point, that the Uniform Act also makes a suggestion that fees should be minimized. though, again, it's not addressed in the Act or Virginia law. And I just wanted to end with a couple of points from the informal meeting a couple of weeks ago. There were some preemption concerns that came up with, of course, a federal law already being in effect, but there is consensus that this act still serves an important gap-filling role. And one suggestion was made to include a savings clause because there is concern that this act could change again. So this would ensure that the Uniform Act is at least as protective as the most current version of the federal law. And that is what I have for you today. Do you have any questions?
Okay, any questions for Casey? Anyone online?
Thank you.
Okay.
Just as a general comment, and the reason I voted against going forward with the drafting committee, I just felt like the ULC could put their resources to a better situation where the gap was so small. And Virginia already had a pretty good statute in place, or culmination of statutes. That's the reason why I voted against going forward with it.
Thank you. All right, Casey, thank you so much. Appreciate your presentation.
Thank you.
I believe that concludes the portion of our agenda with presentations by Division of Legislative Services members. And now item number 8, legislative activity. But first, before I move on, I just would note in your notebook is a memo from Chandler Brooks, which outlines changes to the Conflict of Laws and Trust and Estates Act, which will be before the group at our annual meeting. And Chandler was unable to be here, so he provided this memo, just commended to your reading after the meeting. So for legislative activity, there is a tab for the 2025 legislation. It's an overview of what bills were pursued, and what's not listed there, but just to take note of, is a budget amendment that Amigo was successful in pursuing this past session. Amigo, you want to just speak briefly to that?
Yes, very briefly, Mr. Chairman. The dues for the state's dues went from $70,115 to $73,620, which was a 5% increase. We had already started looking at things to make sure that we had funding that was appropriate to cover all of the costs, not just the dues, but also the travel. In looking at things, we thought that an appropriation of $20,000 would take care of any increase, because right now we were just barely making it. So we went back and looked. The last time that that an increase was made to the appropriation was 2015, and it was about $25,000, and it was because of costs going up. So we didn't get any pushback. Senator Adam Ebbin carried the Senate amendment, and Delegate Cliff Hayes carried the House amendment to the budget. So now our total, our current appropriation was $87,522. With the addition of the $20,000, it's now at $107,522, which would give us some growing room. Just looking, making sure that we can cover the cost of traveling to everything.
Any questions for Amigo?
Next year should be a little less expensive. We're going to Chicago, but then the next year after that, Vancouver is incredibly expensive. I don't know about. I guess our meals and everything are still be all the covered by something else. But I know that the last time I went to Vancouver, I thought it was an expensive place to go.
Sure, I'll just note that my law school is covering my travel expenses, so the Commonwealth won't have to.
Great, wonderful, thank you.
Wow.
And that's actually good to know, because what we budgeted things out of is if everyone went, and every year there's one or two of us who don't attend, but and we cover the costs for staff, for Emma, and sometimes for me if it gets close. So.
Okay, Amigo, thank you. And I would just note that Delegate Hope introduced Uniform Healthcare Decisions Act this past session that needs some input from a variety of stakeholders. I know that AARP and other groups are interested in pursuing that, so they're the convening authority on talking with the stakeholders before next session. And then probably in our first Uniform Act that was vetoed was introduced by Delegate Watts. And I just want to commend Ellen Dyke for making the trip to Richmond several times to testify in front of subcommittee and full committee, both in the House and Senate, as that bill progressed. I don't know that the veto was relative to the underlying substance of the bill that was introduced, but during the legislative process, a bill that had been previously defeated in the House, patroned by a senator, was tacked on to that bill as it progressed. And the only way to get it out of the conference committee was with that bill attached to it. The governor offered amendments. Those amendments were rejected. As a consequence, he vetoed the bill. But I suspect through Ellen's good work, that bill will be reintroduced next year. And those that were opposed to it this time around will have an opportunity to take another look at it. So I just want to say thank you to Ellen. With that, Emma, the next two bullet points I would ask you to cover.
Thank you, Mr. Chairman. I'll just point your attention to the Virginia 2026 legislative plan. This is compiled for us by the ULC. So I can take no credit for it at all, but it does have helpful information on recommendations that the ULC has made of acts that may be appropriate for Virginia. It also runs through acts that are more recently approved by the conference, and any sort of notes about conversations that we as a delegation may have had, or that the commission may have had, recent legislation on the topic. It also points out some recent enactments that we have had, so that we can pat ourselves on the back a little bit for that one, or you all as the commission can do that. So we tend to, hold on some of these discussions until after acts are finalized, and we get closer to the legislative session. But Mr. Chair, if there is any legislative planning to be done for 2026, now would be the appropriate time.
And I would say today, as I've said in the past, if a commissioner has a particular interest in a bill, or a proposed Uniform Act that they want to pursue, then have at it. We just would like to know about it, and so that we can coordinate and make sure we're not headed after the same patrons in that process. And Emma's correct. Typically at the conference, we have a legislative lunch on Monday. It is organized by the ULC, and it's an overview for our particular region. I know we're included with DC. I'm not sure what the other states are. I think it goes up to Delaware. And at the conclusion of that lunch, we typically take a little bit of time to talk about 2026, particularly for the acts that may be before us on final reading at that particular meeting. But then after having some time to review the work of Libby and the others at the main office of the Uniform Law Commission, we can also discuss other acts that may be of interest to the commissioners. Any questions about that? Tom?
Because I'm brand new, there are a number of acts on this list that are in my wheelhouse, but what kind of staff support or help do we get in helping to enact these? I'm thinking, because there I am in Arlington, the legislature is here. I'm not exactly networked. I'm new to the Commonwealth, but I have substantive expertise in some of these areas that I'd be delighted to pitch in with.
this legislative services staff is totally nonpartisan, and Amigo can probably address this more than I can, but we've always taken a standoff point when it comes to proposing or assisting with, we've explained bills if we're asked to at committee meetings. And I think Emma has probably helped some in maybe getting patrons, or at least suggesting people that might be interested in introducing things. But as far as having DLS staff out promoting the bills, that's something that we've never gotten into. And I don't know, I'm sure Amigo probably has the same position on that. So it's up to, in our ULC Constitution, that's the job of the commissioners, is to try to get those things through. So what we've done in the past is, you know, if somebody's been on a drafting committee, to maybe be one of the people that assist if this group decides to go forward with the act. And we've had people from up your way. Connie Ring was very much a proponent on all the ULC bills, and he was our main spokesperson for all that, who we've now lost. We've got Chris is a lobbyist, so he doesn't want to use his network and chits for this, I'm sure. But I'm sure he does what he can without putting out too much.
I will, by way of example, Ellen chaired the drafting committee for the relocation of easements. So she took the lead on finding a patron for that. And then she was responsible for showing up at committee to explain that. I sort of ran back up in case the weather was such that she couldn't make it. We do have opportunity for remote testimony as well, which will be helpful. Year before last, I did find patrons for the revisions to the UCC. So those were two separate acts that we did. Separate from that was a completely independent effort to have the electronic wills bill introduced. And I did, unfortunately, get caught up into testifying in committee for an extended period of time on behalf of the Uniform Law Commission. So, you know, we will do that as far as expressing support or offering to a patron who is interested in pursuing a Uniform Act expertise to have on hand, such as yourself. And I do know for Ellen's Act, we did have someone else who was at the ready as an expert that would testify if needed. So, you know, as we go through this, Tom will look for opportunities to highlight your expertise. And if there are things that you're interested in pursuing, we can talk about the best way to effectuate that.
That sounds great. Yeah, because I'd certainly like to pitch in to the extent that I can. And I think that's probably more in subject matter expertise than in legislative connections.
Chris?
Mary?
It's Mary. I was going to say, I think one of the things with Tom that would be helpful is utilizing his connections to support legislation that's within his wheelhouse. Electronic wills being an example. Tom, if you know people within the Virginia bar, was it Cree Deeds who was a problem on that bit particular? Am I allowed to say that out loud?
Well, you said that.
I just did say it out loud, didn't I? But if we identify who the patron was and then what the objections were, Tom may be able to help with that a little bit as well. And that's just one concrete example. And I guess I better stop talking because I may use someone else's name that I'm not supposed to. Okay.
Thank you, Mary. Ellen?
Just wanted to say you can get a lot of help from the Uniform Law Commission itself. They have all kinds of documents for each one of these acts that help you go through the process. They will also have someone come out here, if that's what you want, and go through the process with you or the hearings with you. And a good idea is, and how we can all help, is to map out where you should be going. Now, it might not be that Chris wants to go and do it, but he can sure tell you who you have to go and speak to, or someone from the Uniform Law Commission to go and speak to about a certain act. So we can provide you with certainly expertise to help you maneuver the legislative process and to tell you where to go. And the Uniform Law Commission can give you all kinds of information and people to come down here and help you move it through the committees you have to move it through. So there's a lot of help out there.
Right, thank
One
you,
other
Ellen.
thing is that, if I may, if you have an agency that has oversight over the statute or what you're doing, an example was I was the chair of the Uniform Certificate of Title on boats, motorcraft. And I got the Department of Game and Inland Fisheries behind me, and they came in and they were just incredibly good witnesses because they wanted the act. And if you work with the agency on that and they get behind you, they can be the big proponent for getting a Uniform Act through.
One other bit of background information. You probably know we have a mandatory bar in Virginia, but we also are one of 4 states that has a voluntary statewide bar, the Virginia Bar Association. And once in a while, one of their sections, from a substantive point of view, will be interested in one of these acts. If we can get an endorsement out of the Virginia Bar Association and get them and their lobbying expertise brought to bear, that has sometimes been helpful. It doesn't happen on every act by any means, but because they don't have a section that relates to everything we do. But when they do, they can be a resource. The state bar, not so much because it's prohibited from lobbying, as you know. Yeah.
Okay, any other questions, comments on legislative activity? Emma, anything else we need to cover? Okay. So when you get to the conference, you'll see, like I said, on Monday, I think, of the conference is when most of the legislative lunches are. I would encourage everyone to attend ours, and then we will briefly meet afterwards if there's time. Beyond that, next agenda item is other business. Is there any other business that we have before us? Hold on, I got one more. I got public comment. Is there any member of the public that would like to comment that is physically present in the room? If you have a comment and you are watching this, you can email Emma Buck, EBUCK, @dls.virginia.gov. Okay. Now, if there's nothing else, I would like to, as EM is indicating, thank Legislative Services. And before we depart, I see Lane has a comment. Lane, you're still on mute.
You're on mute, Lane. Lane.
Thank you.
Floor is yours.
I wasn't able to go last summer, so I don't know what we did in Boston. But we have traditionally had a dinner one night, and with everything filling up, it's been Monday night for a long time. I know there was some thought on our group that we didn't want to do that anymore. Are we going to have a dinner this year or not?
Lane, it's an excellent question. I think the reality became everyone had something each night, whether it's a life members dinner, new members lunch, things like that. And I think for this meeting, the legislative lunch will be our one time to get together for fellowship. And if there's informal opportunity otherwise that we can find, we will discuss that when we get there on Friday, just to see if there's something else separately by way of lunch or something like that. But there is no organized activity this time, and we did not do that in Boston either. So just so you know. Any other comments or questions?
Chris? Chris?
Yes.
I just wanted to say that I'll probably be getting in touch with you so that you can help me understand Boyd Graves. because that's where we're going next with the Uniform Easement Relocation Act. So I just want you to know, if you see a phone call from me, that's what it's about.
I'll make sure to take it. Thank you, Ellen. Okay, anything else? If not, I'd like to thank everyone again for their attention. Thank Division of Legislative Services for their attention to the presentations and the detail that was offered. It was very much appreciated. Congratulations to the 2 law students for suffering through. You did an outstanding job, and look forward to seeing all of the commissioners at the annual meeting in mid-July. Thank you so much, and with that, we are adjourned unless there's an objection. Hearing none, we are adjourned.
The Senate of Virginia, Richmond, Virginia.